That wraps up today's breakdown. Over the next few months, there are still key hearings ahead, including motions and an upcoming jury trial, so the case is far from over. It will be interesting to see how his decision to represent himself plays out as the proceedings become more complex, especially when procedural requirements like witness subpoenas come into focus. Either way, I'll continue following the case and provide updates as new developments unfold.
All right, looks like we have Ms. Spradlin back with us. Ms. Spradlin?
Yes, Mr. Brem has indicated that he does not wish for the assistance of the public defender at today's bond hearing, and I advised him about his right to remain silent.
Okay, and so Mr. Brem, my understanding is that you're waiving your right to counsel with respect to the hearing today, is that correct?
Yes, Your Honor.
Okay. Mr. Brem, do you need further reading or advisement regarding the charges? I can do that here quick. It looks like, let me pull up the warrant here, just give me 1 second. The charges are possession of a weapon by a previous offender, which is a class 5 felony. That's punishable by 1 to 3 years in prison. Could be as many as 6 with aggravating circumstances, 2-year term of parole, and up to a $100,000 fine. You're charged with protection order violation, 5 counts of that. Each is a class 2 misdemeanor. That's up to 120 days in jail and up to a $750 fine. You're charged with possession of a controlled substance as a class 1 drug misdemeanor. That's punishable by up to 364 days in jail, up to a $1,000 fine. There's a $1,000 drug offender surcharge and 24 hours of useful public service. And then you're charged with possession of drug paraphernalia, 5 counts of that. That's a drug petty offense. It's punishable by up to a $100 fine and 16 hours of useful public service. Do you understand those possible penalties, sir?
Yes, Your Honor.
All right, concerning bond and the protection order, Ms. Shishin.
Thank you, Judge. In this case, we're actually asking the court to increase the cash bond that is previously set. The reason for this request is that Mr. Brem has 6 prior felony convictions, and he posted surety bonds in 2 cases in Garfield County that are pending, one for possession with intent to distribute and the other for distribution. He now has 12 pending charges along with protection orders and these bonds, and even in light of that, he is in the possession of 3 long guns and ammo. He is made it clear he's not going to abide by court orders, and we believe him to be a threat to community safety. So we would ask that the bond be increased from the $5,000 cash bond that was set. We're asking for a standard protection order, no firearms, weapons, or ammunition, and relinquishment, no drugs, pretrial services, and testing.
All right, thank you, Ms. Shishin. Ms. Bradley?
Yes.
Wait, no, I'm sorry. Mr. Brem, I forgot you were representing yourself on this, Mr. Brem.
Yeah, so I'd ask the courts to lower my bond. I have community ties. I'm taking care of my mother at the house. In regards to the other cases, they're being suppressed and being dismissed. As far as this case, it was an illegal seizure. I wasn't even in the vehicle when they arrested me or when they came up to me. So the vehicle was an illegal seizure. It was against my Fourth Amendment rights. I just asked the courts either modify the bond to a PR bond or lower it to a just reasonable amount that I could post. I have no intentions of running or being a flight risk. I plan on taking care of this. And yeah, I work with my brother. He keeps me busy. And then when I'm not there, I'm helping my mother. She's, older, has heart problems, and I'm the only one there to take care of her.
It's always striking when someone talks about having people relying on them, yet ignores those responsibilities while making reckless decisions, whether that means violating protection orders or illegally possessing multiple firearms despite prior felony convictions.
Well, the court looks at 3 factors when I determine what an appropriate bond would be. I look at whether or not somebody's a flight risk, whether or not they're a danger to the community, whether or not they're a danger to a specific person. In this particular case, the court would note that Mr. Brem has 33 lifetime failures to appear, only 4 in the past 5 years, but that certainly is something that's concerning to the court. The court also notes that Mr. Brem has a very extensive criminal history that includes similar types of allegations in the past. He's currently out on bond on multiple cases where he's charged with felony offenses, serious felony offenses, including distribution. The allegation is that there is some drug involvement in this particular case combined. with possession of a firearm, which is certainly concerning from a community safety perspective. The question is whether or not those concerns can be mitigated through non-monetary bond conditions. And looking through the criminal history, the court determines that they cannot be managed through non-monetary bond conditions. Mr. Brim, from this court's perspective, it's an in or out decision. I either set a PR bond with conditions, or I set a very high cash bond that's designed to hold someone in custody. And so in this particular case, the court is going to go for the latter. I am going to set a high cash bond that is designed to hold you in custody, at least right now. You will be able to litigate those suppression issues that you mentioned beforehand. And obviously, I'm not going to be your assigned judicial officer. It's going to be Judge Barrett. And so right now, what the court is going to do is set a $25,000 cash-only bond in this particular case. I am going to make a requirement to the bond that if Mr. Brim posts it, he reports to pretrial services supervision. A condition would be no use or possession of controlled substances without a doctor's prescription, no use or possession of marijuana without a valid medical marijuana card, and pretrial will be authorized to test to make sure that Mr. Brim's in compliance with that. The court is also going to order that Mr. Brim not possess or use weapons or ammunition as a condition of his bond. I am going to issue a mandatory protection order that says that Mr. Brim shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that he's charged with committing. Further, he cannot possess, purchase, or control a firearm or other weapon or ammunition as part of this mandatory protection order. Mr. Brim, do you understand those conditions of the mandatory protection order?
No, I don't understand any of this. This is unjust and unreasonable.
Why do you not understand that you can't harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that you're charged with committing? What's not?
I do not consent to any of this. I don't consent to these proceedings. I'm here under special appearance.
You don't need to consent to it. I'm just asking if you understand that, sir.
No.
What if he has a consent of surety from both bondsmen?
That's a separate issue. A consent of surety would be in those other cases. I don't know who that is or how they unmuted themselves. I thought that we had this on so that people could not unmute themselves. That does appear to be the status. I'm not exactly sure what's going on. So anyway, the court declines to address that. We're not going to be talking about reinstating any sort of other bonds or having a consent of surety. And so that's what the court is going to do. Mr. Brim, I do need to advise you that if you were to violate the mandatory protection order, you could be punished for contempt of court. You could be charged with a misdemeanor, or you could be charged with a felony for retaliating against or intimidating a victim or witness of the crime charged. This case is assigned to Judge Barrett's division, Mr. Brim. And so what we're going to do is bring you back to court for formal filing on Thursday, January the 29th. At 8:15 a.m. At that time, you'd be able to readdress that issue of bond in front of your assigned judicial officer. Mr. Brim, would you like us to appoint counsel to represent you on this case so they can help you with that bond argument?
No, I don't consent to any of this.
Okay, well, at present, we won't appoint the Office of State Public Defender to represent Mr. Brim based on his wishes, but you'll be back in court on January 29th at 8:15 a.m. All right. Well, that concludes this hearing then for today. And so why don't we go ahead and call our next case, which is going to be...
He'll now be spending more time behind bars. Moving on, the next hearing is much shorter and centers around his attempt to reduce the $25,000 cash bond previously set during arraignment.
Your Honor, the people believe bond is appropriately set in this case. Mr. Brim has 6 felony convictions, the most recent 2024. He's currently on surety bonds in 2 felony cases out of Garfield County. He was found in this case with 3 firearms and a knife, which are violations given his prior felony status. He has 4 failures to appear in the last 5 years, 33 in his lifetime. So I have community safety concerns and court appearance concerns and would object to modification.
There's also another case. I think he may have been issued a summons for possession of a controlled substance at the time of his arrest in this case. It's not on the CPAD.
Your Honor, I elected to combine those 2 cases.
Oh, okay.
I felt like there were double jeopardy concerns separating them because it was all kind of in part of one incident. So the charges in that separate affidavit are compiled into this singular case for Mr. Brim.
Okay. I guess you haven't dismissed that case yet, though.
Oh, if it's still pending, I will make sure to do that. I thought it hadn't been filed, so I will.
There's a 26M 232 that is a controlled substance and protection order violation case. And Higgins is the one who wrote the ticket. I don't have any information other than that within the file.
If you want to call that case, Your Honor, I would just dismiss it on the record. Otherwise, I'm going to file a dismissal.
No, I'll let you look at it and make sure that that's what we're all talking about, the same thing. So the primary purpose of bond is to ensure that a defendant appears at each and every future court date. Other purposes of bond are to ensure compliance with conditions of bond, as well as community safety and victim safety. When fixing bond, I do consider a host of statutory factors. I've considered them all here, even though I may not mention them. The statutory factors include, but again, are not limited to ties to the community, criminal history of appearing for court, and considering any empirically based scoring instrument that may assist the court in understanding the defendant's risk level should he or she be placed on bond. The defendant didn't complete the empirically based scoring instrument. He refused to do so, so I don't have a score for him, but I would imagine it would be, at least in my mind, close to a category 4, if not a category 4, indicating the highest risk to fail while on bond. That's due to a host of different factors. One, he was on bond in 2 different cases at the time he was contacted by law enforcement in this case. One involved possession of a controlled substance as a class 3 drug felony. There's also a class 1 drug misdemeanor there. That's Garfield case 5017 from last year. Then in early January, there was a warrant issued for his arrest. He's now been charged in that case for class 2 drug felony, possession with intent to distribute. He has 33 lifetime failures to appear, indicating a high risk to not appear at future court dates. I will acknowledge, however, that of those failures to appear, only 4 of them are in the last 5 years. He was also on summons in a lesser traffic offense from earlier this year. The allegations in this case are very serious and involve the defendant allegedly possessing a number of firearms as a prohibited person. In addition to the possession of the firearms, there were a number of other very concerning items found within a vehicle he was alleged to have possessed: a skeleton key, numerous different types of drug paraphernalia, bolt cutters, and the like. He has 6 prior felony convictions, one of which is a vehicular eluding conviction, indicating, in addition to those failures to appear, a high risk of flight. I also am familiar with Mr. Brem. He was in front of me some years ago where he had chosen to represent himself and ultimately received a 4-year sentence to the Department of Corrections. He had a number of other cases pending at the same time in Garfield County, just as he does now. The bond in this case was set at $25,000 cash only. That is a very reasonable bond in the court's mind. We're talking about guns, drugs, 3 felony cases of serious nature being opened in the last year, or substantially less than that. We have a history of failing to appear and an aggravated criminal history. The defendant was given chances on not 1 but 2 different surety bonds before he picked up the charges here. Clearly those aren't working, so another surety bond would not meet the purposes of bond. The court has concerns about all of those statutory factors and the primary purposes of bond being met. So at this time, I'm going to leave the bond as set.
Given the allegations, prior felony charges, multiple weapons, drugs, and suspected burglary tools, it's not hard to understand why the bond was set so high. The defense argued he wasn't inside the vehicle when everything was found, but that may not matter much depending on the evidence presented. Still, he did manage to post the $25,000 bond and is now out of custody as the case moves forward.
Miss Crane is here for the people. So, Mr. Brem, we did this once before, several years ago. As I alluded to, I didn't allude to it, I said it. It didn't go well for you. You ended up with 2 years in prison consecutive to another case that you were serving from another jurisdiction, if I believe correctly. I went back and looked at the minimus. I'm going to go over the same questions I went over with you then, and I'm going to tell you a lot of the same things I tell you then. And the reason I'm bringing up what happened in that other case is because it didn't end well, you representing yourself. History is usually a good indication of future success. Ms. Marasich is an excellent lawyer. She knows what she's doing. I've seen her in court. I've seen her in trial. I've seen her get good results for clients in trial. You don't want her to be your lawyer? That's fine. I'm not going to stand in the way of you making that decision because it's yours to make. But I'm not going to let you make that decision without a full awareness of a few different things. Once we go down this road, sir, there is no turning back. You change your mind in a week because you file a bunch of motions that I deny because they're baseless, because you don't know the law, because they're procedurally incorrect, and you want her to come back and do it right? Not happening. You want advisory counsel? Don't count on it. You want to do this alone? You're doing it alone. You don't have the right to advisory counsel. You want to hire a lawyer to represent you? That's fine. You can pay out of pocket and get a lawyer at any time. What I am talking about, to be clear, is Ms. Marasich and the State Office of the Public Defender. Once you make this decision, like I said, there's no turning back. Do you want me to go through this questioning with you now for you to make this decision? Do you want to spend a few moments to talk to Ms. Marasich about what it is you want to do? Or do you want to read something from a sheet of paper that looks like you want to do?
Yeah, I understand the risks the court has outlined. I'm making a knowing, voluntary, and intelligent waiver of counsel under Feretta versus California. I've already successfully litigated a suppression hearing in Garfield County, which is basically the merits of this case. So,
what case was that, sir?
2025 CR 5017.
Just because someone gets lucky one time doesn't mean the odds will keep falling in their favor. That's why most lottery winners never hit the jackpot twice.
You understand that you have the right to have counsel appointed to represent you because you're indigent and I have appointed counsel to represent you. You understand that?
Yes, sir.
You understand that if you can't afford a lawyer, I will appoint a lawyer to represent you.
Yes, sir.
You understand the penalties you're looking at in this case, sir?
Yes, sir.
Really? What are they?
Well, I believe, what is it? 2 to 6 with mitigating factors. Aggravated is 6 to 12.
It's 1 to 3, up to 6 years on counts 1, 2, 3, and 4. So 1 to 3 years in the presumptive range, all the way up to 6 years in aggravated circumstances, as little as 6 months in mitigated circumstances. So combined, the total sentence you could potentially be looking at would be, 24 years. If you were maxed out on each and every offense. But then you have a number of misdemeanor charges. Do you know what the penalties are for those charges, those class 1 misdemeanors?
Not off the top of my head, Your Honor, but I've been told them already. But again, this is all based off of an illegal seizure of my truck.
We'll figure that out at a later date.
Okay.
364 days of jail on each protection order violation. The drug misdemeanor, class 1, I think that's 180 days if it's a first offense. The drug petty offenses, of which there are a few, that's up to 10 days in jail on each offense. Do you understand those possible penalties?
Yes, sir.
2 years of parole, to be clear, would follow your sentence to the department on counts 1 through 4. Do you have any legal training?
No, sir.
Okay. How far did you go in school?
A little bit of college.
Okay. When did you graduate from high school?
2011.
And where'd you go to college?
Community college in Rifle.
Okay. What'd you study in college?
Well, I only did a semester, but I was going to try to be an engineer.
Okay. You were successful in Garfield County with some motions issue. That's good. So you have some experience of the criminal law. We've already talked about you being in front of me before where things didn't go as well for you. So you have adverse experiences with the criminal law. Do you understand that the criminal law is a very complicated area and that people go not only to college, but graduate from college and then go to law school, graduate from law school. That's 3 years. Then they have to take a test that you have to pass. That's not easy. That a solid percentage of folks in Colorado fail even after all that schooling. And then after that, once they become a lawyer, in order to end up in this courtroom as a prosecutor or a public defender, generally go through several years of experience as a lawyer. Do you understand that it's a complicated field? It takes a lot of education, takes a lot of experience to be proficient at this work.
I do understand that, Your Honor, but I feel like I'm the best one to present my own case because I'm the only one that's basically there. And yeah.
Okay. Do you know most people would say that's why you're not the best person? Do you know, you ever heard the phrase, the person who represents themselves in court has a fool for a client? You ever heard that before?
I have not, Your Honor.
It is a phrase.
Okay.
And do you know what it means?
No, if you wouldn't mind explaining it.
Well, here's the reality. People who choose to represent themselves often end up creating more problems than solutions. In this case, he seems far more confident in his own judgment than the situation probably warrants. But apparently, a semester of community college engineering has convinced him he can somehow outmaneuver the legal system on his own.
The person who represents themselves has a fool for a client. They don't know better than what they're doing is probably against their interests because they're so invested in the issue at which they're trying to argue that they don't see it from the outside looking in. You're looking at it from the inside as someone who lived it, as someone who believes firmly you're right. You saw it, you were there. You can't separate yourself from the incident, whatever it may be, the personal nature of it, such that you're missing things. That's what that phrase generally means. Would you agree with that, Ms. Marsich?
Yes, Your Honor.
That's what it means. You understand that?
Yes, Your Honor.
Do you understand that you have the right to remain silent and that anything you say can and may be used against you in future court proceedings? Saying something as simple like, yeah, that was my car, might make it easier for the prosecution to prove their case against you. Do you understand that?
Yes, sir.
This goes to what I've been trying to say all along to you, Mr. Brem. If you represent yourself, do you understand that you are taking a grave risk of messing this up?
Oh, definitely, Your Honor.
If you definitely know that, then why wouldn't you want to have someone who's got years of college experience, years of legal training, years of experience as a seasoned attorney to represent you and navigate these waters for you? Why do you think you're going to do a better job than that human? Is it because of the one time you were successful in Garfield County or something else?
Well, if you want to be completely honest, Your Honor, it's because I believe it's just a conflict of interest. I'm the only one that has my own interests in mind. You get the paycheck from the state. Both of these ladies get their paychecks from the state. Anyone doing any kind of investigatory work on this case gets paid by the state. You guys are all on the same team, get drinks at the same bar, talk about the same things.
You think I drink with Miss Marsich?
I don't. It was just, I don't really think that.
You think I drink with Miss Crane?
I have no idea.
You think my paycheck comes from the same place her paycheck comes from?
Ultimately.
Are you listening to yourself say these things, sir?
Yes,
do you really think this? And do you really think what you're saying is true?
To the best of my knowledge.
What is your knowledge, sir? You just said you think I drink at the same bar as Miss Marsich, and you acknowledged not 10 seconds later that you have no idea if that's true. It's not.
Okay.
So, to the best of your knowledge, what is that knowledge that you personally hold that leads you to this conclusion?
It's just my belief. That's as far as I'm gonna go with it, Your Honor.
I'm sorry?
That's as far as I'm gonna go with it.
Okay.
Because,
And I think you said we're all on the same team.
Seems that way.
I may have misheard that, but I think I heard that.
It just seems that way, Your Honor.
If I was on Ms. Crane's team, does it sound like I would be cautioning you to not have Ms. Marsic as your lawyer? I'm sorry. Right. If I was on Ms. Crane's team, what do you think I would be doing right now? Telling you to have Ms. Marsic as your attorney, or telling you to go at it alone with no legal education, no training? Think about that for a moment. You don't have to answer it.
Okay.
It's kind of obvious. It should be. Do you know Ms. Marsic, sir?
No, Your Honor.
Have you ever seen her in court?
No.
So your beliefs are based on something, and you don't...
It's not like a personal, like, her or you. I'm just speaking in general.
Okay.
Correct me if I'm wrong, if you guys don't get all paid by the state.
I don't. The state of Colorado, she gets paid through the county, Ms. Crane. Ms. Marsic gets paid through the state office of the public defender, and I get paid through the judicial branch. Our checks come from 3 different places. We have different benefits, different retirement plans. We don't work for the same people.
Is it all the government though still?
That's a pretty broad term. The president gets paid by the government. Congressmen get paid by the government. Anyone in government gets paid by the government. State government get paid by state government. Local government get paid by local government. If it's so easy for you to associate where my paycheck comes from or where someone's paycheck comes from to them all being on the same team, then there's nothing I could ever say to change your impression other than think about that for a moment. Is it really that simple? Maybe it is to you. Mr. Brem, do you understand you have the right to confront and cross-examine witnesses, have them subpoenaed, come into court and testify on your behalf subject to the rules of evidence, which you may or may not know?
Yes, sir.
What does that look like? Not what they might say, but how you would go about subpoenaing them, getting them to come to court.
Well, to the best of my knowledge, I would just file a motion, and then they should already be coming because they're the ones that are trying to prove my guilt. I don't really need to prove my innocence, even though...
Right, you are presumed innocent. You are presumed innocent. But let's say you've got a witness who you want to call to testify on your behalf. How would you go about getting that person here to testify on your behalf?
Well, if it was someone I knew personally, I would just ask them to show up, and I would file a motion to let the people know that I'll be bringing somebody in.
What if they decided not to show up?
Well, I would cross that avenue when it showed up. I'm sure I could look it up and figure out how to do that.
He's chosen to represent himself, but he's already struggling with fundamental courtroom procedure, including how to properly subpoena witnesses. At this stage, it's less about confidence and more about a lack of familiarity with how the process actually works. Still, the court has to proceed according to standard rules, even if it's clear he may be starting at a significant disadvantage.
Do you understand that if you wanted to have someone subpoenaed to be compelled to come here and testify, that I would issue those subpoenas and compel them to be here on your behalf?
I
do now?
Well, I believe I've actually read that already, but, I do now for sure.
Okay. And I think you probably already covered this, but do you understand that if you wanted to, you could confront and cross-examine witnesses as they testify for or against you? I guess that would be against you if you're confronting them and cross-examining them. But you understand if the prosecution puts a police officer on the stand or whoever they want, subject to the rules of evidence, you would be able to ask them questions. You understand that?
Yes, sir.
Mr. Brem, have you talked to Ms. Marsic about this decision at all? Or did you just file that motion saying you wanted to fire her and proceed pro se, and that was kind of, I don't want to get into your discussions with her beyond. Do you want me to let you to talk? I'm getting, it's been a long day for the court. Do you want to talk to her for a few moments about some of the things that you're thinking about? Your issues in terms of suppression, her evaluation of the case, what you might want her to do, whether she's comfortable doing it. I mean, anything like that before you make this important decision, just so you can have that chance. I'm happy to give it to you.
No, thank you.
Okay. Are you under the influence of any, I think I asked this, any drugs or alcohol right now?
No, sir.
Are you thinking clearly?
Yes.
And to be crystal clear, you understand that if you do a terrible job of representing yourself, you can't come back and you get convicted and you go to prison or you get put on probation or whatever it is. You can't come back and say, I was a bad lawyer representing myself. I was a bad pro se litigant, and therefore the judgment should be reversed because of how bad I was. Do you understand that?
Yes, sir.
Mr. Brem. Is that what you want to do, is discharge Ms. Marisic and represent yourself?
It is.
Had enough time to think about it?
Yep.
Thinking clearly today?
Yes, sir.
All right, I'll find that the defendant has knowingly, intelligently, voluntarily, despite the court's admonitions and Arguello advisement and inquiries, chosen to represent himself. It is his choice and his choice alone. He has a full awareness, based on my colloquy with him, of the consequences of his decision, and to the extent that there are benefits, the benefits as well. It's his decision and his decision alone. Ms. Marisic, thank you very much for your time today, ma'am, and for sticking around. You're free to go.
Yep.
All right, Mr. Brem. So you're subject to the same pretrial order that I issued previously?
Oh, yeah, in regards to that, just, like to address my motion to modify bond. And I'd like to also, if we could in any way, like, speed up the evidentiary hearing, like.
No, the date is the date. I picked the date.
Okay.
You've posted your bail in this case, so you want me to change it?
Yeah, I do.
Okay. The motion I already denied from a couple of weeks ago?
I didn't know you denied it, Your Honor.
I did.
Was it on the basis of I had a lawyer or a public defender?
It was.
Okay. Because I believe the first one I entered was the one basically trying to vacate her.
Right, but that doesn't happen until we have the conversation we just had. You filed a constitutional challenge to punitive bail, and you said, I indicated on the record, I intended to set a bond so high you could not post it. I never said that.
I believe you did, Your Honor.
No, I didn't.
Okay.
I don't even believe I set your bond, Mr. Brem. Your bond at $25,000 cash only.
Was set by Rom, but then.
No, was set by Judge Burrell.
Oh, okay.
And then I denied your request to modify it. So I didn't set it so high that I was intending to deprive you of an ability to post your bond. Judge Burrell said it. I denied it for the reasons I stated on the record. And that's not language I ever use. I don't set bonds with the intent of keeping people incarcerated. So on that request, one, I mean, it doesn't appear the bond is excessive because you've now posted it, right?
It's still excessive, but, you know, yeah.
Okay. Tell me why you think it's excessive. And remember, you have that right to remain silent.
Well, basically, you know, it's supposed to be set of the least restrictive means.
Mm-hmm.
And also, there's just, it all stems from an illegal search. Like,
Well, I don't know that yet.
okay.
What else? Is somebody texting you, sir?
No, sir. It's just the notes I have.
Mr. Brem, let's get on with it, please.
Okay, let's get the findings of fact on why, basically.
The judge has already made this point clear on multiple occasions. The allegations include unlawful possession of firearms, drugs, and items consistent with potential burglary activity, along with reported protection order violations. In that context, the court's focus is on the seriousness of the conduct and the appropriate legal consequences, which could have been significantly more severe depending on the circumstances.
I gave you all of those findings at the time I denied your request to modify bond previously. I make a relatively thorough record every single time.
Is it possible to get that in writing?
No.
No.
You can order a transcript at your expense.
Okay.
And I can tell you, I'll be happy to tell you the date and time we held that hearing. But I denied your bond request in part, and I would do so today because of your extensive criminal history, your history of failing to appear, the fact that you have multiple open cases, the nature of these allegations, guns, protection order violations.
I'd ask the court to...
I think, I'm sorry, I kind of phased off there, but I'm sure that was the general reasons why I denied it. And I would continue to deny it for those reasons. Any modification, you've posted it.
Well, the defendant at least moves to basically dismiss pretrial services because it's just the $25,000 cash is already like a pretty...
The reason the $25,000 cash is as low as it is because of the pretrial services condition. If you take away the pretrial services condition, then the monetary conditions of bond need to be increased. Put differently, the pretrial services condition is one that allows me to keep the monetary conditions lower because I can have faith that you're complying with conditions of bond.
Isn't that kind of like a pre-sentence thing?
It is not. If you knew the law, you would know that.
I have nothing else, Your Honor.
Okay, great. Ms. Crane, anything else we need to take up today?
No, Your Honor.
So, Mr. Brem, I want to make sure that you understand kind of what the next steps are going to look like in terms of just procedures. You filed a number of motions because you were represented by counsel. I denied them all. You're welcome to refile them all. That's fine. I want you to know when the motions are due because this is important for your deadlines. Do you want me to print out the pretrial order? I can give that to you now.
That'd be appreciated.
Yeah, let me print it out for you and then I'll just repeat it. I think it should print here.
That wraps up today's breakdown. Over the next few months, there are still key hearings ahead, including motions and an upcoming jury trial, so the case is far from over. It will be interesting to see how his decision to represent himself plays out as the proceedings become more complex, especially when procedural requirements like witness subpoenas come into focus. Either way, I'll continue following the case and provide updates as new developments unfold.